Today is September 22nd, 2022. This is Orleans Superior Court Civil Session with the Honorable Judge Richardson and Assistant Judges Hardy and Batchelder presiding. Case before the court at this time is docket number 22-CV-3278, Dylan Gingues versus Lori Perkins et al. And there are a number of people that are on the platform. And this is a telephone status conference.
Sorry, I was just going to say we have Attorney Robert Menzel for the Attorney General's office.
Okay. So I'm going to start this hearing. This is Judge Richardson. I'm going to start this hearing. I'm going to actually ask Attorney Menzel because the court has not heard from the state in this matter about his initial thoughts. Then, Mr. Gingues, I'm going to come to you and ask for your thoughts. The purpose of this hearing is to determine next steps that we take in this habeas corpus petition. And just as background and as framing, I'll simply note that habeas corpus proceedings are intended to be a quick and summary procedure for relief from illegal imprisonment unimpeded by appeal and review by the state. And that's from the In re Fitz case from 1964, Vermont, 124, Vermont, 146.
What do you mean unimpeded by appeal?
It means that it's simply that it is intended to be a quick and summary procedure that is separate from the appellate process that you may have a right to go through. And I'll explain in the next sentence. Habeas petitions are not an additional avenue for appellate review. They are essentially a civil proceeding brought to test the legality of restraints on the person. And so that's the purpose of a habeas petition, is to really test is the individual who is being held under a legal process, not to challenge the decisions that were made in said legal process, but simply whether or not the state has the right to hold the person. So in that respect, it is not it's not an opportunity to revisit the substance of an initial hearing or to serve as a collateral to an appellate process. It is really intended as a separate and limited process for that respect. So that said, I'm going to go to Attorney Menzel. What is the state's position? Mr. Gingues, I'll get to you in a minute, but I'm going to go to Attorney Menzel first. Go ahead, Attorney Menzel.
So, Your Honor, the state's position is that this matter, there's a few defects with the complaint to the extent that individuals who are named under habeas, the intent is to name the individual who maintains custody of the complainant who is alleging that they're being unlawfully held. In this case, that would be Lori Perkins and or the Department of Corrections. So as a preliminary matter, we would suggest that any of the other defendants that are named should be dismissed from the case because they're not appropriate pursuant to the habeas statute. The state's position is that this is not actually an appropriate habeas petition because in addition to the language that you said earlier, Your Honor, the Supreme Court has noted in Shuttle v. Patrici that habeas relief does not provide a substitute for appellate review. And the court in that decision, Shuttle is 158 VT 127 from 1992. They also noted that when there are other remedies available, courts do not grant a writ except in rare and exceptional circumstances. And that's also from the Shuttle decision. And the basic gist of this is that I guess I should step back to the extent that Mr. Gingues is suggesting that he's being held illegally. The state, and in particular the Department of Corrections, would state to the court that his detention within the Department of Corrections is based on a bail minimus that was received from the Orleans Superior Court Criminal Division, holding him on $10,000 bail. The department doesn't make decisions about who to hold or why to hold them. We basically hold people that we are ordered to hold based on an order from the court. We have a valid bailment from the court, and we're holding him in regard to that bailment. So there's nothing unlawful about his detention from that perspective. To the extent that he's attempting to challenge the imposition of bail and particular conditions of release, we would suggest that this is not appropriate for habeas review, because there is a bail review statute and process that's in place to address those very issues. In fact, Mr. Gingues is scheduled for a bail review in front of the criminal division of the Superior Court at 1:15 today. So the habeas petition is premature at this point, because Mr. Gingues has not exhausted his bail review avenue that is available to him. And in a case that just came out in December, the Supreme Court indicated that petitioners can't gain a tactical advantage by bypassing alternative remedies. That was the Davey decision. And in that case, an individual had been violated on furlough and was attempting to seek review of that through the habeas process, and the Supreme Court held that he couldn't do that because he had to go through the process that was set up in 724 to appeal the suspension of furlough. And this is a similar type situation where there's a bail that's been set, there's a bail review process that's in place to allow for the review of bail, which culminates ultimately in an appeal before a single justice of the Supreme Court. None of that's been done. The bail review was filed on the 20th. Today's the 22nd. So, I mean, this is just a premature application for habeas relief that's not even appropriate, given that there are other alternatives out there that have not been pursued by Mr. Gingues.
Okay. Thank you, Attorney Menzel. I will come back to you, but I want to talk. I want to hear from Mr. Jang. What is your position on steps forward, Mr. Jang?
Yeah, so I mean, I don't see where it says in the statutes or anywhere else that these other remedies need to be taken first before filing for a writ of habeas corpus, or petition the court for a writ of habeas corpus. In regards to the bail conditions, I do know that I noted that bail conditions is one of the issues, that I have onerous bail conditions. So give me a second here. I actually didn't receive my 5-day or 48-hour bail review hearing pursuant to 13 VSA 7554. I've also had a extremely hard time getting letters to the court. It takes a long time, so my access to the court has been very restricted, and including the law library, so I haven't been able to pop over all the RSAs that I'd like to. I haven't got to go to the library, law library at all. And I have, as I mentioned, that the bail conditions are onerous, and I have a few cases here that talk about that. It's been said that onerous bail conditions are equal to no bail. So this case doesn't actually reference that, but Bell versus Wolfish, 441 U.S. 520 1979, says that the fact that an individual may be unable to pay for a bond, however, is an insufficient reason for subjecting him to indignities that would be appropriate punishment for convicted felons. Nor can he be subject on that basis to restraints that might properly be considered regulatory with respect to particularly obstreperous or dangerous arrestees. An innocent man who has no propensity towards immediate violence, escape, or subversion may not be dumped into a pool of second-class citizens and subject to restraints designed for regulate others who have. For him, such treatment amounts to punishment. And because the due process guarantee is individual and personal, it mandates that an innocent person be treated as an individual human being and be free of treatment, which, as to him, is punishment. And I think you know that where I am is exactly a place where people who are sentenced and are dangerous are currently serving their sentences. I am in the same situation, being treated the same as them on pretrial detainment. And being denied access to things that are very important to my defense is I am not represented by anyone. Furthermore, Bernstein versus Pa, 420 U.S. 103, 1975, the consequences of prolonged detention may be more serious than the interference occasioned by arrests. Pretrial confinement may imperil the subject's job, interrupt his source of income, and impair his family relationships. See Goldfarb, Ransom 32-9, 1965, L. Gates Justice is the Crime, 51-62, 1972. Even pretrial release may be accompanied by burdensome conditions that affect a significant restraint of liberty. See example 18 USCC 3146A 2 and 5. When the stakes are this high, the detached judgment of a neutral magistrate is essential if the Fourth Amendment is to furnish meaningful protection from unfounded interference with liberty. Accordingly, we hold that the Fourth Amendment requires a judicial determination of probable cause as a prerequisite to extended restraint of liberty following arrest. So in regards to the probable cause, I think that the state needs to show cause as to why they're holding me here, and so that brings up another question as to there was other respondents listed in the Habeas Corpus writ petition. So why is it that only Lori Perkins is in this hearing as a respondent?
I will. Well, I think so. Anything else, Mr. Jang, at this point?
Yeah. So in regards to well, if you could answer that first, that would be helpful. But yeah, there's other stuff I want to point out here in regards to the lack of cause shown.
Judge, I can inform the court that I'm authorized to appear here on behalf of Judge Warren in a limited capacity. So that was part of the reason I raised that issue of dismissing her from the complaint.
Yeah, I would object to that.
On what basis, Mr. Jang?
That she was listed as a respondent in this habeas petition, and that she's the one who has ordered me detained here.
But she's
I'm
not
not even quite sure who.
She's not the one detaining you physically. That is the point of, as I understand it, Attorney Menzel's argument is that in a habeas case, it's not a review of the terms and conditions that were set upon you at your initial arraignment and bail hearing. It is who is holding you now, and do they have a legal right to do so? So in that respect, the only defendant is anyone who is holding you, and Judge Warren may have made the determination that your bail be set at these levels and these conditions be imposed, but she is not the one who is holding you at this point. Like any, judge, if you go back before her for a bail hearing, she may alter the terms of your bail, but for purposes of habeas review, it is not an opportunity to review the terms of those conditions of release or bail. It is an opportunity to simply test the legality of this, of your being held. And to that respect, the only defendant need to be named is Ms. Perkins as she the warden, Attorney Menzel of
She's the superintendent at Northern State Correctional Facility.
Yeah, so that's as I understand, that's what Attorney Menzel is arguing. So, Mr. Jang, um, unless there's a particular basis for continuing to have the other individuals named, I'd like to hear that if that's your position. You know, why is that your position? What basis? What does the court have?
Let me ask you this: why did you guys agree to hear this petition? Why did you think it might hold merit?
Well, no. To be clear, a habeas petition, when it's filed, if it sounds as a habeas petition, comes forward, and part of the reason why we have this pretrial hearing is to determine the next steps forward, including, are the parties named the correct parties? So in that respect, you did name Ms. Perkins, who the state has said is the correct person, is the correct defendant. But it's saying these additional individuals that you have named aren't the correct defendants in this case. So the court's agreeing to move forward on this does not constitute any finding that there is anything other than issues raised within the scope of habeas. And so in that respect, there hasn't been any adjudication or decision as to the merits of this case, but simply an initial screening to determine whether or not. And to just give Mr. Jang and give you an example, sometimes petitioners file a case and it's not really a habeas case, it's a Rule 75. They have not been, they have had something taken away from them under the corrections rules and regulations, and it's not a habeas. And so the court may, if it reads the petition, say this is not a habeas, it's a Rule 75, and we'll move it to a Rule 75 process. You have raised habeas claims in your petition, and that's why we're here. And now it comes down to the fact of how do we adjudicate these and what's the best way moving forward. So, Mr. Jang, what else do you wish the court to hear at this time?
So I guess I'm not seeing why questioning the legality of the order to hold me here is somehow not valid. I mean,
sorry,
the state hasn't. I said I guess I'm not seeing how questioning the validity of the order to hold me here is not valid. I mean, is that what you're saying? Then?
No. What I'm saying is that's the question. The question is about the legality of the order. As the court indicated at the beginning of this, this is really a question about testing legality, not testing the wisdom of Judge Warren to have imposed the conditions. The court's not here to second guess those. It is here to say, was the process followed? Is the petitioner, in this case you, being held improperly? That's the real issue for habeas. It's a quick and summary process. So there are a couple of different options that you have before you, and the court's happy to go through this habeas process and review. Habeas is a very important and essential right, and so the court is compelled to review habeas cases, and that's the other part, is that when a petition comes in that talks of habeas, that it sounds in habeas, as they say, the court goes forward with it until there is a motion or a showing by, usually in the state, as to why the habeas is not necessarily meritorious, or in the contrary, that it is meritorious and the relief should be granted. But the court on its own will not dismiss a habeas petition normally unless there's some threshold standing issues in which the petition really never gets off the ground. So, for example, if the habeas petition is filed by one person in the name of another, that would be a reason to dismiss it. But other than that, it relies upon the parties to adjudicate this, because this is really an opportunity to challenge that you know,